Good evening. My name is David Van Cleve, and I'm the president of the Harvard Law School Forum. Tonight's event marks the kickoff of the Forum's spring 1989 season. We're pleased to have with us tonight William Sessions, the director of the FBI. To introduce Mr. Sessions, we are also pleased to have with us Professor Phil Hyman of the law school faculty. To introduce our speaker this evening, we welcome Professor Philip Hyman. After graduating from Harvard Law School in 1960 and clerking for Justice Harlan on the Supreme Court, Professor Hyman worked for the Office of Solicitor General and in the State Department, where he held a number of different positions, including Deputy Assistant Secretary of State and Executive Assistant to the Undersecretary of State. He began teaching at Harvard Law School in 1969 after he worked at the District of Columbia Legal Aid Agency. Professor Hyman was an associate Watergate special prosecutor and took another 3-year hiatus from Cambridge when he served as the Assistant Attorney General in the Justice Department's Criminal Division. That was from 1978 through 1981. Along with being a professor here, Professor Hyman is also the director of the Harvard Law School Center for Criminal Justice. I'm pleased to welcome Professor Phil Hyman.
Thank you, David. I want to run very quickly through a similar biography for Judge William Sessions, but you have it in front of you, so I'm going to be quick and then turn just for a minute to what a job he has. Bill Sessions was born in Arkansas in 1930. That makes him 58, which to me seems to be just about the ripe age of wisdom. He went to Baylor University both as an undergraduate and got his law degree there. He practiced in Waco, Texas from 1958 until 1969, when he went to the Department of Justice, the Criminal Division, one of the absolutely most important and desirable places to go, where he headed the Government Operations Section in 1969. In 1971, Bill was appointed United States Attorney for the Western District of Texas. In 1974, he was made United States District Judge there. I first ran into him when I was head of the Criminal Division, and there was a massive FBI effort to identify the killer of Judge Wood. Judge Wood was from the Western District, Bill? Correct. He was from the Western District. He had been assassinated by gunshot. We had a massive investigation which ended up very complicated, FBI paying a lot of attention to it, and it ended up in trial in Judge Sessions' courtroom. On November 1st, 1987, Judge Sessions resigned his position as United States District Judge to become Director of the Federal Bureau of Investigation. I read in the paper at that time that his predecessor, Judge Webster, had said to him, "One thing that I can promise you is that you will not be bored." Is that true?
Yes, close
That's
on.
Close on. I want to close the introduction by just suggesting to you what an extremely difficult and challenging job it is to be director of the FBI. You have to have a very high measure of fairness, of wisdom, of cleverness, of political savvy, and of managerial skills. Now that's a very rare and difficult combination to have. Judge Sessions heads a very large institution, 10 or 12,000 agent personnel, 9,500 agent personnel. It has a broad sense of responsibilities. We think of it at law school in terms of its criminal responsibilities. It's responsibility for solving crimes, basically involving complicated crimes, large organizations. We don't hear, except occasionally, about its responsibilities for counterintelligence in the United States, worrying about espionage against the United States, counterterrorism. he has a basic responsibility for for Senator Tower's investigation prior to appointment or non-appointment as Secretary of Defense. The FBI has administrative and sort of nationwide management responsibilities that are imposing. It is the source of identification and record keeping for criminals across the nation. It has the lead in law enforcement technology. It trains the police of the United States on a relatively massive scale and the police of other nations on a substantial scale. The FBI itself is the symbolic leader of law enforcement agencies in the United States. It's in that role resented and admired by all the other law enforcement agencies, of which there are half a dozen, but it is the leader. It has developed a recent tradition of, just as old as Judge Webster and Judge Sessions, of making a judge its head, of symbolically saying that the law and lawyers and judges are what control law enforcement in the United States. Seems to me a wonderful symbolic tradition, 2 directors old. I hope it continues forever. But the job is an extremely difficult one, and it's risky being a symbol of rectitude and skill and judgment and management of an institution as important, as powerful, as needed, and as feared as the FBI. Judge Sessions occupies that job, and I think we're doing well. I'm glad he does. Bill?
Professor, I thank you for that kind introduction. I note that you're aware that my wife Alice is here, and I hope she held on every word and will know what a manager I am and what a...
She actually gave me the statement, though.
Marvelous, marvelous. I also am very aware that I am home in Boston again. My daughter attended school up here for a number of years out at Natick at Walnut Hill School for the Performing Arts. So over those years we became familiar, and as she did, have fallen in love with Boston. It's also very nice to be in the home halls of a man for whom I have deep respect. You're a former dean and the now president of Harvard University, whose works I've read. I'm always very interested that there are more students here now than I suspected might be here after his famous report to the trustees, where he suggested it might be appropriate to limit the enrollment of law students. I'm glad it didn't take effect at Harvard. You must know that I'm very honored and pleased to be here as a part of the forum. I have very carefully written down a number of simple words that relate to a very complex operation within the Department of Justice and the Federal Bureau of Investigation, thinking that they would be of a particularly important nature to you as law students in your understanding of some of what I consider to be the important issues of the day. So I want to talk to you about something that's very important to me and to everyone at the FBI. I want to talk to you about it in the context of the importance of civil liberties, because civil liberties these days are quite properly on everybody's mind with the very difficult investigations that the Federal Bureau undertakes. I want to then give you a better understanding, or what I think might be a better understanding, of the challenges that the FBI faces. That is, balancing the use of very sensitive investigative procedures that penetrate criminal organizations and yet at the same time are able to protect the rights of citizens in these great United States. I would like to begin with a story about a city in southern Florida that is being torn apart by the drug scourge. In Miami, Florida, as you well know, drug dealers can be found everywhere. Violent crime is rampant. Young people despair of ever getting out of their situations, and older people, of course, fear to walk the streets at night. and fear for their very lives because of what drugs have brought on to that community. Now, the FBI, along with the Drug Enforcement Administration, the United States Customs Service, the Coast Guard, the Internal Revenue Service, ATF, and other federal agencies that Professor Hyman mentions, are battling side by side with the federal agencies and local law enforcement agencies to stop the flow of cocaine and heroin and other controlled substances in that community and from that community outwards around the United States. Under the FBI, during the past 6 years since 1982, and under our national drug strategy, we are responsible for attacking major drug trafficking and money laundering organizations that are dealing in heroin and cocaine. So the story that I'll relate to you as an example, I think, has particular application in that context. In mid-1987, agents from our Miami field office began an undercover operation in a particular drug area by setting up an electronics store in the area. These undercover agents, knowing that one of the vulnerabilities of drug traffickers is the fact that they must be able to easily communicate with each other by electronic means, were able to gain, through the establishment of that store, that electronic store, the confidence of a number of Colombian drug traffickers by selling them beepers and cellular phones and navigational devices and shortwave radios, and to proceed to train them in them and to repair them for them and to work with them in connection with their need for this kind of communication capability. Through the use of sensitive investigative techniques, including informants, electronic surveillance, and other undercover operations, the FBI was able to obtain critical information about drug shipments. We determined the locations of cocaine-laden freighters and sailboats in the Caribbean and in the Gulf of Mexico, which were heading to the United States and into the Miami area. As a result of that particular investigation, and it has not gone to trial, so I need not identify it, but as a result of that, some 92 people in the United States and abroad have been indicted. But even more importantly, we have severely, and I hope permanently, disrupted the ability of those particular Colombian drug cartels to transport and to distribute their drugs in the United States, and in the process seizing many of their assets as a part of that investigation. Now, in this case, as in many others that the FBI conducts, we are involved in sensitive investigative techniques, and I've mentioned 3 of them. So I want to talk to you more about those particular 3 tonight, because I want you to know about this technique and what those techniques are and how and why we use them, and how we try to balance the use of them against the privacy rights of the individuals involved, and what successes we have had with them. As Americans, and I think Professor Hyman will adopt this view, most of us are offended by any intrusion into our private lives. We don't want our telephones tapped. We do not want to be watched as we go about our daily business. We don't want to be searched. These things are very sensitive to us, and as lawyers we need to be very sensitive to the circumstances that arise under the Constitution of the United States. On the other hand, we are also angered in our society if it is not protected from those who want to do it harm. We don't want terrorists to kidnap or to kill innocent people. We do not want spies selling our technology and our military secrets to our enemies. We do not want drug dealers ruining the lives of our citizens and terrifying and terrorizing our communities. Now, how can the FBI, which is charged with enforcing the federal laws that protect our society, bring terrorists and spies and drug dealers to justice, and at the same time protect the rights and the freedoms of individuals? I think part of the answer is clear. That is, that through the lawful use of sensitive investigative techniques, we can successfully attack this criminal conduct in a fashion totally compatible with the Constitution of the United States, both in its written form and in its intent as expressed by the courts. I know that some people are perplexed about why we must use these techniques. Why not just do what the FBI has done for years? Interview witnesses, search out crime scenes, physically observe a suspect until he or she is caught in the act, and other endless normal investigative techniques. Well, these more traditional techniques may be enough to catch bank robbers, to catch kidnappers, to catch car thieves, and to catch fugitives. But the kinds of circumstances where I've mentioned here tonight generally defy those normal investigative techniques, and they are found to be repeatedly unsuccessful or not complete enough to establish and bring in the evidence that will convict by convincing a jury beyond a reasonable doubt that the crime has been committed and that the person who is charged is the person or are the persons who have committed it. But what happens if there are no witnesses to question? If there is no crime scene to search and there are no suspects to follow and observe? Who do you question about a Colombian drug trafficker and what he is doing or she is doing? What physical evidence is there of a corrupt public official, and what does he or she leave behind? And how do you begin to develop serious suspects of a bombing if a number of terrorist groups claim responsibility for the deed? Today, criminals, I believe we all accept, are much more sophisticated in many other operations than their counterparts were 40 to 50 years ago. Gone are the days of Bonnie and Clyde and John Dillinger, when most criminals were within the reach of the long arm of the law. Today's sophisticated criminals do, in fact, insulate themselves from the law by surrounding themselves with others who do their bidding and who commit the crimes, the actual substantive crimes in many events, for them. Today's criminals have also taken advantage of the advances in communication and in technology, and now possess such sophisticated equipment as I've described for you in the case in South Florida. We are dealing with an entire new class of criminals. Criminals like terrorists and drug kingpins who know their trade very well and who are expert in all phases of it. Those criminals who were virtually non-existent 40 to 50 years ago. These new types of criminal organizations to which they belong can seldom be penetrated by our more traditional investigative techniques. Therefore, we need techniques which will reach into these criminal enterprises at their highest levels. I'd like to focus on these three techniques and discuss with you the techniques that facilitate our mission to reach into the upper echelons of criminal organizations. That is, the use of informants, the use of court-authorized electronic surveillance, and the undercover operations and how we proceed with them. First, a few words about informants. Informants are called the single most important investigative tool in law enforcement, and I adopt that view. The greatest problem in solving a crime is knowing who committed the crime, and this is where the informant is important. The word informant sometimes has a negative connotation, but the FBI informant category includes any individual who willingly provides information of a criminal nature and requests confidentiality. The motivation of these individuals may be moral, it may be patriotic, or it may be self-serving, but the end result of informant cooperation is the solving of cases and the bringing of criminals to justice. We use informants to gain information on criminal activity. We use them to recover stolen property, to locate wanted persons, fugitives from justice, and to detect crimes in the planning stages. Above all, we use informants to put our undercover agents in contact with criminal organizations. How do we choose informants? Obviously, we choose them with great care, since we can and have had some of them backfire on us. First, we're looking for someone in a position to furnish information or provide operational assistance. And second, we look for someone who is willing to help. I want to emphasize that we don't use informants indiscriminately. If we can obtain the same information in another, less intrusive manner, we try to do that. The FBI protects its informants by keeping their identities secret. We also make very sure that each informant operates in strict compliance with Attorney General guidelines. We keep records of what informants have been instructed to do, what they have done, what they have been paid, and how they have been and what they have produced. We regularly check the informant's information to make sure that the individual is truthful and reliable, and we periodically review the informant's file to ensure that the informant is being operated in compliance with all FBI rules and procedures, as well as with the Attorney General guidelines. FBI informants are not used by the FBI to circumvent legal or ethical restrictions. They are given specific instructions not to participate in acts of violence, not to use unlawful techniques to obtain information, or to initiate a plan to commit a criminal act. They are advised that if they violate our rules, they will be subject to prosecution by either federal or local authorities. There are some examples that you might be interested in. Strategically placed informants have been at the core of virtually every major long-term organized crime, drug trafficking, white-collar crime, and domestic terrorism investigation that has been conducted by the FBI over the past few years. Those cover 4 of the 5 major areas of priorities that the FBI has. That is organized crime, white-collar crime, terrorism or counterterrorism, and drug trafficking. For example, in the La Cosa Nostra Organized Crime Commission case, with which many of you are familiar, we were able to obtain indictments of the leadership of 5 New York organized crime families. How did we reach the leadership? Well, from evidence that came from court-authorized electronic surveillances and from informants who provided us with the information we needed to show probable cause in order to get the electronic surveillances approved by the court in the first place. Also, in August 1987, you may recall that the FBI was able to arrest a Lebanese terrorist in international waters of the Eastern Mediterranean because of the assistance of an informant. As you may recall, this terrorist had been an alleged participant in the hijacking of a Royal Jordanian airliner in Beirut, Lebanon, which held a number of U.S. nationals without the use, that held a number of U.S. nationals, and that without the use of an informant, that terrorist would probably still be at large in the Eastern Mediterranean. Incidentally, the arrest of this terrorist marked the first time that an individual had been arrested outside the continental United States and returned for prosecution in the United States for violation of the recently passed extradition legislation, extraterritorial legislation, pardon me. This legislation gave the FBI extended jurisdiction in certain terrorism matters and, among other things, made it a criminal offense to take a U.S. person hostage during a terrorist act. I'd like now to turn to the use of court-authorized electronic surveillance, one of the most effective and valuable techniques used in both criminal and national security investigations. With Title III of the Omnibus Crime Control and Safe Streets Acts of 1968, with which Professor Hyman is very familiar, and the addition of the Electronic Communications Privacy Act of 1986, Congress has provided a comprehensive statutory basis for using court-authorized electronic surveillance in investigating violations of certain major federal criminal statutes. These violations include organized crime activities, murder, kidnapping, robbery or extortion, obstruction of justice, hostage-taking, mail fraud, and the manufacture of or trafficking in narcotics, marijuana, or other controlled substances. However, since electronic surveillance is such an intrusive technique, we must meet very stringent requirements and show probable cause that evidence of criminal activity will be intercepted by it before a federal judge will approve the application. And we use only this technique in those instances where other investigative techniques would not or could not or have not worked. The case agent in an FBI office, as an example, prepares an affidavit in support of an application for Title III electronic surveillance. It is then reviewed by the principal legal advisor in that FBI field office, then by the United States Attorney's Office, and by supervisory personnel in the FBI field office. Thereafter, if everything is in order, that is then sent to the FBI headquarters in Washington. In Washington, our legal counsel division, criminal investigative division, and the attorneys at the Department of Justice then scrutinize every affidavit in support of that particular application. We then refer that application, including the affidavit, to the Attorney General or his designee for authority to file it in federal court. The application is then submitted by a United States attorney to a United States District Court judge. When the application involves particularly sensitive circumstances, my special assistants and I also personally carefully review and then I approve it. Since the application is authorized by the federal judge, it is good for up to 30 days, and we prepare reports periodically during that time period to keep the judge abreast of what is happening with that particular wiretap. We must reapply for extensions if we need them every 30 days. Now, Title III electronic surveillance has a number of safeguards built into it by the statute, including a requirement to discontinue the interception during a non-criminal conversation and when attorney-client privilege might be involved. These minimization procedures protect the individual privacy and maintain a proper standard of fairness. The application and the affidavit submitted by the FBI Title III electronic surveillance must include a description of the minimization measures that the Bureau plans to take during the time of the operation of the Title III. Now, a good example of the effectiveness of the court-authorized electronic surveillance is the recent case concerning alleged bribery and fraud in the Pentagon procurement process, with which I believe you're all familiar. This 2-year investigation, conducted jointly by the FBI and the Naval Investigative Service, made extensive use of electronic surveillance. As a result of this surveillance, we were able to identify individuals involved in dealings between consultants, some defense contractors, and certain government officials. In January, the first indictments were returned, and guilty pleas have been obtained and are entered, and I presume that more are expected. I want to talk for a minute about the Foreign Intelligence Surveillance Act of 1978 and pass on briefly after discussing that. Up to now, I've been talking about sensitive investigative techniques involved in criminal investigations, but I wanted you to know that these same techniques, when used in foreign counterintelligence investigations, are managed in much the same way. The restrictions and the guidelines which the Bureau must follow in case of national security are equally as stringent because of the very nature of the foreign counterintelligence investigations. For example, when seeking authorization for electronic surveillance of a United States citizen under the Foreign Intelligence Surveillance Act of 1978, we must establish, to the satisfaction of a special federal court, that the subject is an agent of a foreign power. Now, I want to discuss briefly with you the undercover operations and our involvement in them and how they are handled. There is a third type of investigative technique which has been utilized over the years by the Federal Bureau of Investigation, and many of you are familiar with it, and that is our undercover operations. Many times these have become very glamorized, but our undercover agents are trained professionals who work long and hard to infiltrate criminal organizations of one kind or other. It is not easy to associate with criminals every day for extended periods of time, and our agents do need special counseling because of the effect of that kind of association. Our agents also face, obviously, a great deal of danger. But because of their work, we are able to reach into the upper echelons of criminal organizations, bring their leaders to justice, and put them out of business. An undercover agent can provide unique first-hand testimony in a court of law relating to the nature and the scope of the criminal activity. And particularly when it is a long-term investigation, the use of informants in undercover capacities is particularly impressive to a jury listening to that evidence and very important to the investigation of the case. The activity and the extent of the involvement of various offenders and the location of the evidence are all things that can be uniquely obtained when you have an undercover agent involved directly in the operation and observing it. This testimony, along with the physical evidence and the information obtained from electronic surveillances, is, I believe, an unbeatable combination to be bringing it into the courtroom for presentation to a jury before a court. The use of undercover agents who can testify in court about criminal enterprises increases the chances dramatically of having a conviction in those cases. That means that it's not always necessary to offer immunity or reduce charges to defendants or to use convicted felons or former Confederates in order to prosecute higher echelon subjects. It also means that our informants often will not have to testify in court so that their identities remain secret and they will be safe from physical harm and can continue to provide information on other matters. Obviously, this is a very important matter to the Bureau. As with other sensitive investigative techniques used by the FBI, undercover operations are conducted under strict Attorney General guidelines and are subject to many levels of FBI approval before they can actually be implemented. And like the use of informants and court-authorized electronic surveillance, undercover operations are used only if the more traditional investigative techniques would not or could not work. In accordance with the Attorney General guidelines, there are two kinds of undercover operations conducted by the Bureau. One type, which is approved at the field office level by the special agent in charge, or the SAC as we call him, involves the gathering of information on a limited basis with limited funds. The second type, which involves a substantial expenditure of money and/or sensitive circumstances, must be approved at FBI headquarters in Washington. The approval process for an undercover operation is very stringent and must be followed every time an operation is imposed and proposed. It begins in the field, where the undercover scenario or proposal is prepared. As I said earlier, if the operation involves a limited amount of information gathering and funds, the special agent in charge of that field office can approve it. But any other undercover operation scenario must be forwarded by that special agent in charge to FBI headquarters for review and for approval. Once at headquarters, the operation scenario goes through the Criminal Investigative Division, which reviews it and then submits it to our Undercover Operations Review Committee. This committee is made up of representatives from the Criminal Investigative Division, the Legal Counsel Division, and as Professor Hyman might have noted, with attorneys from the Department of Justice. These representatives very carefully assess the benefits to be obtained from the undercover operation, as well as the number of other factors, such as the risk of invasion of privacy, the risk of harm to private individuals or undercover employees, and the suitability of undercover employees or cooperating private individuals participating in that particular undercover activity. That committee then forwards its recommendations to the head of our Criminal Investigative Division for final approval. If, however, the operation involves particularly sensitive circumstances, the committee forwards its recommendations to me directly for approval. The FBI has had many successful undercover operations that have struck at the very heart of some criminal organizations. One example I'd like to share with you is a 3-year money laundering investigation which we in the FBI call the Cash Web Expressway case. The purpose of that investigation was to identify and gain enough evidence to prosecute individuals at the highest level of 3 money laundering syndicates operating in South America and in the United States. During Operation Cash Web, FBI undercover agents operating out of a number of FBI field offices were able to work their way into the inner sanctum of these Colombian drug trafficking organizations by gaining the confidence of their members. Our undercover agents were asked to transfer almost $500 million in drug proceeds to Colombia. They actually laundered approximately $175 million. As a result of the Cash Web investigation, the FBI arrested the hierarchy of 3 major Colombian money laundering organizations. In the process, we also seized 2,500 pounds of cocaine, 22,000 pounds of marijuana, and $25 million in cash. We could not have concluded this investigation successfully without the use of undercover agents who had direct contact with the members of these drug cartels. When using any sensitive investigative technique, whether we are dealing with criminal activity or threats to national security, the FBI is always accountable to the public through the provisions of the Freedom of Information and Privacy Acts, through the close scrutiny of the media, and through the various congressional oversight committees to whom we answer concerning our activities. My assistants and I have testified and will continue to testify on Capitol Hill on the value of using sensitive investigative techniques. We are also willing to listen to recommendations made by those committees on how we can better serve the public and how we can better carry out our responsibility. In order to ensure that these sensitive investigative techniques continue to be used by our agents in a fair and lawful manner, we provide a wide variety of legal training to our special agents. Our new agents during the course of their initial training are required to take legal courses on, among other things, the Constitution and the Bill of Rights. These courses are designed to sensitize the agents to the constitutional limitations on their authority. Our special agents in the field, as well as those at FBI headquarters, regularly attend legal seminars, in-service training, and refresher courses on the latest legal issues. Here in the United States, we have for over 200 years prided ourselves on the rights provided by our Constitution and the guarantees it provides to each of our citizens. Many other nations do not have such rights and do not have a Constitution which so closely requires the guarding of civil rights. We also pride ourselves on the knowledge that we are able to live freely and safely in our society. The FBI is responsible for enforcing the federal laws that protects our society without infringing on the rights of individuals. How can we strike a balance? I believe we can do that by conducting lawful investigations, by closely following our statutes, our guidelines, our Attorney General guidelines, our rules, and our regulations, by striving for fairness and by seeking to always balance the concerns for liberty and for constitutional sensitivity. I want to thank you for allowing me to share these few minutes with you and to discuss these three techniques which I believe in law school training can be of great help to you in understanding the functioning of the FBI and its responsibilities under these statutes. And Professor Hyman, I want to express to you my thanks for being here with me and sharing the evening with me and introducing me as a former member of the Criminal Division of the Department of Justice. Thank you, sir.
If there are questions and answers, please feel free to come up to either of the microphones and address Judge Sessions.
Well, I have a question. Yes. Now, this is a native Texan. I can tell by the way he walks.
Last week on McNeil-Lehrer NewsHour,
Yes.
CIA Director William Webster spoke of a desire to work more closely and in connection with the FBI. Do you agree with, on some projects, do you agree with your predecessor's comments, and what are some examples how the CIA and FBI could work closely together?
Well, in the foreign counterintelligence area, both the FBI and the CIA have a responsibility. But the FBI is limited to the continental United States in the activities that it carries out. And the CIA is excluded from operation within the United States. So that our interfacing and our exchange of intelligence, information, are gaining the ability to work together on cases both that they handle out of the country and we handle in this country is very important. It's important in many areas, not just the counterintelligence area, but in the sharing of information that relates to other areas of responsibility, such as, for instance, terrorism. I think that the circumstance concerning Pan American Flight 103 would gain for you or allow you to observe firsthand the importance of the cooperation and the sharing of intelligence between those two agencies. And it is singularly very important. I'm fortunate in the circumstance that became mine to come to the FBI following William Webster, and for whom I have the greatest respect. And he, of course, left me with an FBI that was extremely well run and with a circumstance there that was very easy to take over and to step into his shoes and try to carry out those responsibilities. Yes?
Yes, my question involves FBI activities on college campuses.
Yes.
I was wondering, generally, does the FBI have a policy of placing or recruiting college students on campuses to kind of keep their eyes open, as agents looking around or, for particular activities?
No.
No, okay. Secondly, knowing a couple of people who, through the Freedom of Information Act, have found that the FBI has established files on them for some reason.
Yeah.
I was wondering if you could let us know about the criteria involved in deciding whether to establish a file on a college student.
Let me discuss for a minute the Freedom of Information Act, because I consider that to be a very, very important area of discussion. With the FBI, it recognizes very deeply its responsibility to the American citizenry. And yet I would say this to you, that before the Freedom of Information Act, it was seldom contemplated that the files would be revealed to the American public. And so what you find is an amazing disgorging of material even during those periods of time when no agent thought that it would be disgorged. And yet here it is coming out and it's made available, which indicates to you that the material is maintained and that it would always be available under the appropriate authority, whether it was a court who was seeking that information and required that information under the processes of law, or a grand jury that required it, so that it was not gained and then destroyed or hidden unlawfully. So those materials, even as painful as some of them may be, actually have now come to light. The conduct of investigations in connection with the criminal activity is fairly innocuous. That is, where there's criminal conduct that may be involved, nobody disputes it. That is, the necessity of keeping that kind of information. But when you have other sensitive information that relates to other FBI responsibilities, for instance, as Professor Hyman noted, the foreign counterintelligence responsibility, it is not always that easy to delineate or to be certain exactly what you have, because there is not a criminal predicate that is required in that particular area of the law. And so the Bureau, of course, does gain information that may not be related to criminal activity at all and may end up being not associated with a criminal investigation or prosecution, or may end up not being involved in any prosecution at all. And the question is, when you have that material and close out an investigation, what do you do with it? How do you handle it? And of course it is normally handled where it is placed in the indices of the FBI so that it is recoverable. And that's how it comes up under the Freedom of Information Act. And when your student friends have asked for that material, they have found precisely what we have. Probably it has been edited or redacted to take out, and you'll see blank spaces across it if you've looked at it, because it will protect the source of the information. For instance, I talked to you earlier about informants. You would not find an informant revealed in that information. You would not find another undercover technique revealed. You might not be able, even by reviewing it, to tell what kind of investigation it was associated with. But all those materials we are answerable for. And for instance, I was asked tonight about the CISP's investigation, which was an international terrorism investigation at one stage, and much earlier, not an international terrorism, but an investigation on another stage, another phase of the law. In those cases, those materials which were produced, of course, have been greatly redacted, and I think you're familiar with that. And it's a very difficult and sensitive area. But what pleases me most, and to find it as director, was that those records were preserved and they are producible under the law. Yes, sir.
Yes, Director. Many people are familiar with the more traditional FBI role of fighting organized crime and drugs, but I would wonder if you'd speak to the recent gains made in the outstanding FBI laboratories with regard to DNA and genetic identification.
Oh, you have pulled my string. It seems to me, and of course you and I share in common, having known about the FBI for many years, it seemed to me that I've always accepted, long before I became director, that if a crime was solvable, the FBI could solve it. I accepted that its investigative techniques and its identification techniques were superior or at least equal to any other investigative agency in the world. When I came to the Bureau in November of 1987, one of the first things I asked was, what is happening with the DNA? The first thing, by the way, I learned to do was pronounce it. It's deoxyribonucleic acid, and I've perfected it. I wanted to know where we were going because it seemed to me that the forensic application of that technique, which was well established in the scientific community and the medical community, could have great possibilities for us, and everything I had read to that point seemed to indicate that. Mr. Castingay, who is the assistant director of the laboratory division, assured me that they were moving along with it. And I said, well, we will need to put that in high gear. And so what has happened in the 15 months since that time, we have collaborated with scientists from around the world. We have collaborated with those programs which were beginning. Every single area where people were undertaking the DNA possibilities, it was extremely cooperative. And by putting together the study groups of the FBI, which consisted of people who would help us identify the procedures, the techniques, the legal background and underpinning for it, and come up with the standard probes that could be utilized not just by the FBI, but systematically around the country, meant that we were establishing for the United States a central point where the DNA forensic technique could be used to help in the 100% identification in such things as serial rapes and serial murders, those crimes that previously have defied solution, and that we could be particularly helpful to law enforcement. And local law enforcement is the lifeblood of the Bureau. Our cooperation with those local police forces, our serving them, our helping them, our sharing our training devices with them, doing those things which aid us in helping law enforcement around the country is a primary responsibility of the Bureau. So the DNA capability, now established, will give to every police station around the country the ability to know that the FBI has that capability and will share it. And to me, it's extremely important. I can give you about 2 more hours on discussion if you like it. Yes, sir.
Hi. You mentioned the CISPAS investigation.
Yes, sir.
And I wonder if you feel if it got out of hand, and if so, how and what was learned to prevent such things in the future?
To me, it was very important for you to know, and I hope that maybe you were able to see both the coverage of that and the testimony that I gave both before the House Permanent Select Committee and the Senate Select Committee on Intelligence. And maybe you have shared what I thought was a very careful analysis of what I saw and what I did in connection with that. It seemed to me that it's very important in the context that we're talking tonight to know that out of that investigation, which, by the way, cost the Bureau around $800,000 to do it, and spent many, many agent hours actually carrying it out, that out of that we were able to identify by review of all of the files in headquarters, every single file in every single field office where there was activity, that out of that we were able to define and find, and I testified to this, only one single violation of a constitutional right. And that was, on one occasion, an agent took from a bulletin board an announcement of a public meeting rather than copying the information down. He actually removed it and brought it back to the file. Now, there were, of course, many techniques that were utilized there, which were the subject of a great deal of discussion and over which there is disagreement. But there was no violation of procedure in doing that. There was, as a result of that, and which I painfully testified to, a failure on the part of the Bureau itself in its supervisory responsibility to do those things which the managers of that information should have done. And unfortunately, it fell my lot to evaluate that and to discipline, and I did. I feel that that's the only thing you can do with that kind of investigation is very carefully go back and document what you did and see what you did and then submit it to the oversight committees. And I believe that the Senate Select Committee report will be out shortly, and I presume the same thing will be true in the House with Congressman Edwards' committee. Yes, sir.
I was wondering if you might elaborate a bit on what the standards are that the FBI and the Justice Department applies at the inception of such an investigation where the possibility of a legitimate investigative technique infringing upon legitimate First Amendment rights exists. Because as you mentioned earlier, that there is a tension between effectively interdicting crime and allowing people to express perhaps unpopular views. I was wondering, what does the FBI and the Justice Department do to balance those rights at the inception of such an investigation?
A very important question. First of all, I would encourage you to follow through on your question, and possibly I can be of assistance to you, or Professor Hyman can be of assistance to you in gaining a copy of my testimony before both of those committees, because it does detail what I found out, and then it details specifically the steps that were taken internally within the Bureau to actually deal with those problems concerning our failures or perceived failures in that investigation, both at the field level and at the review level at headquarters. We tightened up every single procedure that we could find to tighten up. There are, I believe, some 30-plus procedures that have been changed as a result of that. But particularly important to you, I think, would be that the final review of those procedures is heightened within the FBI, so that it now has a higher level of review. There are also a great deal more sensitive techniques applied. I would also give to you what is a known factor, known well by Professor Hyman, and that is that within the Department of Justice itself, entirely separate from the FBI, there is a 6-month review that takes place in every international terrorism investigation, where the department, independent of the FBI, is required to review and does review and is required to assess and evaluate and pass their own judgment on the vitality or the purposefulness or the legality of that particular investigation. And you will recall that in the CISP's investigation, it was the Department of Justice who early in the spring of 1983 asked the FBI to clarify its position concerning the viability of the CISP's investigation. And it was at that time that the review brought about the decision to close the investigation, and it was. Yes, sir.
The FBI is charged with enforcing the nation's civil rights laws and investigating violations of them. In the last year and a half or so, the press has reported at least 2 very serious cases brought by agents of the FBI against the FBI for racial discrimination, ethnic discrimination. There's allegations and a decision finding systematic discrimination against Hispanic agents and just gross racial harassment of a black agent. And I was wondering what you are doing to reform the FBI in this regard.
Again, it's an extremely important question, and it's one with which I was confronted immediately upon lowering my hand from taking the oath of office as director. First of all, let me say that both of those cases to which you refer, one is the case of Special Agent Donald Rochon, who is a special agent who was assigned in the Philadelphia field office. The second case is a class action under the style of U.S. Pettis versus the United States versus the FBI. Both of those cases are still in the courts, so I will comment on them only obliquely. With the Pettis decision, it was rendered in September. We are still in the process of going through the procedures in connection with the bifurcated trial, that is the split trial on liability and the other area concerning relief. So as late as last Monday, the Department of Justice lawyers and the lawyers for the plaintiffs and the lawyers for the FBI were meeting with Judge Bunn in El Paso to discuss those very circumstances. From the very beginning, in the case of Special Agent Rochon, that case was actually filed 2 days after I became director of the FBI. The Rochon case, as it stands in the public record, had already had some hearing through the EEO process. And I think you may be aware, if you have studied it, that in fact the FBI had complied with the final EEO decision. But it is one of those things that is discussed in the framework of whether or not the penalty that was involved and set out by the administrative law judge was sufficient under the circumstances. When I became director, I thought it was extremely important, notwithstanding the existence of those cases, that we establish very clearly a record of being a non-racist, non-discriminatory agency, and that we had to evaluate every single process, from hiring, through training, through the processes of being able to handle discrimination complaints, through the processes of promotion, through every single process within the Bureau where there might be some taint reflecting an EEO problem based upon racism or discriminatory conduct. When that happened, that is, when we began that, I very carefully kept track of what I called EEO initiatives. And there are a number. They number in the dozens. But basically they cover those areas where I have just mentioned, that is, those particular areas where the discrimination or racism can be found. The second thing that was very important to me was that in spite of doing that I had to be prepared, regardless of what the outcome of those cases might be, to ensure that there was not racism or discriminatory conduct in the FBI against any minority, period. And in order to ensure that I had to be prepared once those decisions came down to see what that judge said and to be sure that our procedures and our policies were consistent with it. So, for instance, as a result of Judge Bunton's decision back in the Pettis case in October, I immediately undertook to devise remedies that met what I felt he was most critical of, and that was the utilization of language-skilled agents in particular investigations, mostly involving drugs. That is where he found a discriminatory action in the utilization of those agents. I have done that. I have responded, and if you're interested in it, it is published in terms of an addendum to a pleading in the Pettis case in El Paso, and outlines approximately 10 pages of specific changes that have been made to ensure that in that program alone that we have no discrimination or unfairness in the application of investigative requirements. To me, this is extremely important. The basis of it is much broader than that. It is my belief that because the FBI since the 1960s has had very definite, precise requirements in civil rights investigations, that because it is the investigative agency charged with that, it would be intolerable to have an agency that tolerated discrimination or racism within its ranks. And therefore, in order for the American public to be able to perceive, and for those people, young people who, for instance, want to be FBI agents and who are members of the minority to perceive that the Bureau was the agency where they wanted to come to, they needed to feel confident that it was not an agency that tolerated racism or discriminatory conduct. And everything I've done almost daily has been bent to that task. And I'm very pleased you asked the question. I would be delighted if you want to leave your name to provide you specifically with the answers to those things which we have done. Thank you. Yes, ma'am.
With all the terrorism targeted mainly against Americans around the world, may I ask, in your estimation, why do you think terrorism has not hit home?
The question is extremely important to me because of the FBI's history. You may be aware that in 1982, the FBI placed terrorism as one of its priority programs. When I say priority, that will identify it as being one of 5. In 1982, there was terrorism and there was drugs. Terrorism and drugs were added as jurisdictions, and they joined white-collar crime and organized crime and foreign counterintelligence. So those 5 today are our priorities. Terrorism in 1982 was declared a priority because of the number of individual incidents that happened in the United States. If I remember correctly, there were around 150 separate terrorist acts that were reported and investigated in 1981. That number has steadily declined until year before last. There were 7, and you may recall that all 7 of those were in Puerto Rico. They were with incendiary and explosive devices that ended up killing nobody and harming nobody, but damaging property. There were 7 this year as well. 4 of them, if I recall, were in Puerto Rico, and 1 of them was in Miami, and there were several other incidents in Miami that might be yet designated as terrorist incidents. The importance of the terrorist priority, that is, our efforts in counterterrorism, is that over the years we have been fortunate in reducing each year the number of terrorist incidents. And again, it goes back into the very sensitive area of the gaining of intelligence and being able to prevent them. We have prevented such diverse things as Sikh terrorists bombing a plane departing from Kennedy Airport for India, and handling that case and convicting those people. We have prevented the assassination attempt on the life of a man whom you know well by his name and by his country. President Ortega, Daniel Ortega. Again, these incidents were preventive in nature. The terroristic acts and the attempts of those people to carry them out were interdicted by the FBI because of information that was gained in the procedures that we utilized, some of which I discussed tonight. To me, the other part of the question is what can we do about international terrorism? The fact that we have been able to have a constant decrease in the number of terrorist acts in the United States has a corresponding reaction around the world where 25% of the terrorist acts performed affect United States citizens. And I think that's what prompted the Congress of the United States in 1986 to allow us the extraterritorial jurisdiction under which we can go and where hostages are taken or property is destroyed and lives threatened, those of United States citizens, anywhere in the world. We can, if we can take those people in international circumstances, we can bring them back and try them. The other part of it is it highlights the absolute essential nature of cooperation among nations. And it is extremely difficult. In the European community, with the European Economic Community, their ministers of justice and their ministers of interior meet routinely in what's called the Trevi Conference. And the Trevi Conference is designed by those groups to deal only with terrorism. And they meet twice a year. They govern themselves by a troika that consists of a revolving group of 3 countries that have a revolving presidency so that each of those nations participate in it. In 1992, the European community will, for the first time in its history, have a common border. And terrorism and the movement of terrorists is extremely important to them and a tremendous threat to them. Because once in the border inside the European community, then there is freedom of movement. Whereas before there were borders, and there were border checks, and there were visa checks, and there were passport checks, there were airport checks, there were all sorts of things that allowed you to interdict a terrorist operation. So it's a tremendous concern. But the Trevi Conference and the participation by the United States in a bilateral arrangement with those countries allows us to participate with those countries and express our concerns and fully gain the cooperation of those countries in the defeating of terrorism worldwide. The other thing that we work very diligently with is called the Italian-American Working Group. Again, its responsibilities are, through law enforcement efforts, to gain information, to share information, techniques, and skills through dealing with international terrorism, dealing with drugs, and with organized crime. And many of the spectacular results that we've seen here in the United States since March of last year, for instance, have been the tremendous major cases against drug trafficking organizations which were solved by the cooperation with the Italians, the Sicilians, and the Americans. So it's very fruitful and very, very helpful to us, both in terrorism and organized crime and in the drug area. Yes, sir. I see 2 now. Yeah, take either one, fine. Thank you.
This worked great. I've got a 2-part question. The first part concerns the undercover operations that the FBI conducts.
Yes.
As an undergraduate studying criminal justice, one of my professors kept throwing these moral dilemmas at me that I never had any answers to.
So they do that.
I was wondering that when an undercover agent, in order to infiltrate a criminal organization, and members of that organization request that the agent commit some infraction of the law in order to prove himself, and failure to do it would basically mean that he would not be able to infiltrate that organization. What type of instructions or guidelines would the FBI give to that agent? And second of all, I was wondering what the
Let me take the first part first. It is extremely important that a person who is a law-abiding citizen in a criminal context be able to identify himself with a lawful purpose. So the undercover committee that I mentioned has a very careful review of all those circumstances. And it's absolutely essential that in every single instance where a person is required to participate in some unlawful conduct, that he or she, if they're going to continue their undercover role, have some solution to it. And the undercover committee assists with that. For instance, are you required in a heroin trafficking ring to become a heroin addict by utilizing heroin? The answer is no. Are you required to do these things which you feel would be destructive of your ability as a law enforcement officer? And the answer is, again, with those people, with dealing with those committees, if they are able to stay within the guidelines of the Department of Justice and the FBI and carry out their role, then they can do it. If they are not, or if they perceive themselves as being not able to, then they would be removed from an undercover operation. The violation of law and the expectation of violation of law is generally by observation and presence, but not by the violation of law itself. It's an extremely difficult area.
The second part, I was wondering what the background research project is, or the process is that you conduct on potential applicants to the FBI, and what sort of information might lead to the rejection of an applicant.
I hope you're planning to give me an application. First of all, it's very important to us and the Bureau, as you would expect, that we have law-abiding people. That we have people who are public service oriented and who are law enforcement oriented. So any person between the age of 23 and 35 is eligible to meet those requirements. It requires a college degree. If you have a supplementary degree, for instance, in law, you may come directly in the Bureau. If not, then you must have 3 years of law enforcement experience, or experience that qualifies in that area. If you are in a particular area of expertise that the Bureau wants, then, of course, for instance, if it's computer technology experience, or you're a skilled linguist, or you're a pilot, and we need pilots, or a helicopter pilot, although some of those are not agents but are actually support personnel. With each of those persons, they submit the same application form and go through the same background investigation. And it is one that would qualify you to obtain a top secret clearance. That is, every person who works for the FBI has the same clearance. That doesn't mean they have the same need to know, but the same background investigation has gone into. The difficult areas are the areas of violations of the law. Candid, truthful responses are absolutely essential because, for instance, some criminal charge might well be explainable. The result of it may not be available through the police records, even though you referred to it. But candid reference to what your life has been is extremely important. That, by the way, follows throughout your career as an FBI agent. Candor is absolutely essential. And without that, and without the truthful application of an applicant, we cannot hope to gain the agents that we seek to find. We struggle always with being able to find people who are law enforcement oriented sufficiently, particularly, for instance, lawyers, who know that by going to the Bureau for a career there, they are always relegating themselves forever to a government salary. And with lawyers, we all know, have many opportunities outside that. So it takes a unique individual who wants that law enforcement career. Of course, I think it's an absolutely fascinating career. At the same time, it does require a great deal of willingness on the part of the applicant to give up those things which materially you might otherwise have. Now, as to the particulars of the background investigation, with those you can gain or get a questionnaire and see those types of questions which are required. They generally are like a top secret investigation, or a secret investigation would be in the military, so that your background is very carefully gone over, and your associations are with your educational training, your associations with the military, your travel overseas, those things which relate to your record, your health are very important. I hope I've answered your question for you. Yes, sir.
This is a question about a petition that's being circulated by a group called the National Committee Against Repressive Legislation that's co-sponsored by a number of professors here at the law school, including Vern Countryman and others. I'm not familiar with it. The idea of the petition is to establish a charter for the FBI wherein loopholes that currently exist which allow the FBI to do things that involve investigating people who are simply exercising their rights to freedom of speech and the political exercise of their rights, as, for example, was done with the Committee in Solidarity with the people of El Salvador, the C-SPACE investigations and break-ins, etc. I wonder, what is your view of such a project to, first of all, have a charter for the FBI and specifically addressing some of these loopholes?
Let me go back, first of all, to the C-SPACE investigation itself. the circumstance concerning break-ins is a particularly sensitive one. Congressman Edwards has supplied us, over the period of time since I've been there, a number of different circumstances where there was a break-in that was indicated by somebody that they thought it was FBI connected. So far as I know, and so far as the investigation as I know it, there has been no single circumstance ever in any one of those where the FBI was involved in any way, shape, form, or fashion with the break-in. The investigation of it after the break-in, yes, we have been involved with the police departments. To me, that's an extremely important facet of it. And I don't mean to contradict the circumstances that suggest that citizens' rights are a danger when there are break-ins, but apparently, as I understand it, there were none of those that we were able to track anything other than vandalism, or that they were in fact the attempts to burglarize and to steal. As to the importance of the underpinning of being sure that the FBI conducts itself within the law and within the Constitution of the United States, I take great comfort in the oversight committees, and there are 6 of them that I report to. To me, it's extremely comforting to know that the Senate Select Committee on Intelligence oversees our intelligence operation. That includes the international terrorism responsibility. And the House Permanent Select Committee does the same thing. And that Congressman Edwards' Subcommittee on Constitutional Rights does the same thing. And I know that, for instance, I will be up there on the 28th of this month talking specifically about EEO matters and about his concern there. I will be directly involved in testifying concerning oversight concerns of all those committees. To me, this is extremely important. There is, in the FBI, as you probably know, a separate division that does routinely, day in and day out, carries out the inspection function. Again, the vigorousness, if that's a proper word, the vigor of that particular group is extremely important, because they must go out and must examine every single circumstance on their checklist to be sure that the FBI complies with its own procedures, its own requirements, its guidelines, the Attorney General guidelines, and the law. And that if they find that there are violations of that, as well as violations of the responsibilities that are audited, that in fact is dealt with directly by the Director of the FBI. So I read those very carefully. And the question that's always asked is, what has happened in this area where there's been a deficiency found? All these are directed at my strong intention to be able to say to the Congress of the United States, if I am inquired of, and I'm sure I will be, that we have taken those steps during the time I have been Director of the FBI to ensure that we are in fact complying with the law and the guidelines and the procedures in the Constitution of the United States. And I covet the support of those committees in telling me where they believe we have not. I think that's why, for instance, the CISPA's investigation began. Congressman Edwards wanted to know. Senator Boren wanted to know. Congressman Stokes wanted to know. And that's why we pursued it. And I presented my work product as fully and completely as I knew how. So you're looking at a man who does not resent that. But I would hope that we would be able to conduct ourselves in such a fashion that the Congress of the United States will not find it necessary to actually have a charter. Yes, sir.
It's an effort to tighten the guidelines, actually.
Say again.
This is an effort to tighten those guidelines.
I think it's important that guidelines be reviewed constantly. For instance, part of the, if you'll recall, part of the result of the CISPA's investigation was my request of the Attorney General that he designate the oversight section of the Department of Justice to review the international terrorism guidelines, and they're in the process now of doing that. And I think it's extremely important. Well, I want you to know that I've enjoyed being here with you. If there are other questions, I'm willing to answer them. If not, I want you to know that I'm very honored to have been here with you and to share this evening with you. I hope that out of the evening of conversation, you came to realize that the procedures, which are in fact controversial in subject matter, are very carefully dealt with and are extremely important to the FBI, because it's extremely important that a major law investigation agency be perceived itself as being totally in compliance with the law. So every single suggestion that it is not, to me, has to be taken seriously and has to be looked at, has to be reexamined, and the basis for it and the cure for it, if it exists, has to be very rapidly applied. But I do thank you, and I've thoroughly enjoyed the evening with you.